Good day everyone, we are the Group 2 and we will discuss the ground for liability. Table of Contents. Meaning of ground for liability: fraud, negligence, delay, and contravention of the terms of obligation. Meaning of delay, kinds and requisites. Effect of delay and fortuitous event. Before I discuss the meaning of grounds for liability, I will introduce myself first. I am Realine M. Morales and let's proceed to the Article 1170. Article 1170. Those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof are liable for damages. Article 1170 of the Philippine Civil Code deals with obligations arising from contracts and negligence. This article emphasizes the responsibility of parties in honoring their commitments and the consequences of failing to do so. Grounds for liability. In grounds for liability, the breach of obligation is voluntary. And what is liability in law? Liability means legal responsibility for one's acts or omission. And for grounds for liability, the obligation is voluntary. Fraud, deceit, or dolo. As used in Article 1170, it is the deliberate or intentional evasion of the normal fulfillment of an obligation. As a ground for damages, it implies some kind of malice or dishonesty, and it cannot cover cases of mere mistake and errors of judgment made in good faith. It is synonymous to bad faith in that it involves a design to mislead or deceive another. For example, Mara obliged herself to deliver to Anna 20 bottles of wine of a particular brand. Subsequently, Mara delivered 20 bottles knowing that they contained cheaper wine. So, Mara is guilty of fraud and is liable for damages to Anna. Article 1170 refers to incidental fraud. Incidental fraud or dolo incidente commit in the performance of an obligation already existing because of contract. It is to be differentiated from casual fraud. Casual fraud or dolo causante, fraud employed in the execution of a contract under Article 1338, which vitiates consent. In the same example, if Anna bought 20 bottles of wine on the false representation of Mara that the wine is that as represented by the labels, the fraud committed by Mara is casual fraud. Without the fraud, Anna would not have given her consent to the contract. She has the right to have the contract annulled or set aside on the ground of the fraud. But in the first example, the remedy of Anna is not annulment of the contract of sale, which is not affected by the incidental fraud, but to claim damages. If the fraud employed by Mara to get Anna's consent was not the principal inducement that led Anna to enter into the contract, the fraud is also incidental and it will likewise give rise only to an action for damages. Negligence, fault or culpa. It is any voluntary act or omission, there being no bad faith or malice which prevents the normal fulfillment of an obligation. It is the failure to exercise that degree of care required by the circumstances. Example of negligence. Jamil is a passenger in a taxi. Here, there is considered a contract of carriage between Jamil and the owner of the taxi company. In consideration of the fare to be paid by Jamil, the owner of the taxi company thought the driver agrees to safely bring Jamil to her destination. If through the recklessness of the driver, like for example, driving at an unjustified rate of speed or entering a one-way street, an accident occurs, as a result of which Jamil is injured, there is negligence which would make the owner liable for damages. If the taxi contained defective parts, the failure to repair the same constitutes also negligence on the part of the owner. Delay or default or mora is the non-fulfillment of an obligation with respect to time. It is when someone does not fulfill an obligation within the time given unto him. Further explanation and information of delay will be given by Mr. Cacho. Contravention of the terms of obligation. This is the violation of the terms and condition stipulated in the obligation without justifiable excuse or reason. The contravention must not be due fortuitous event or force majeure. Fraud and negligence distinguish. In fraud, there is deliberate intention to cause damage or injury, while in negligence, there is no such intention. Number 2. Waiver of the liability for future fraud is void, while such waiver may, in a certain sense, be allowed in negligence. Number 3. Fraud must be clearly proved, while negligence is presumed from the violation of a contractual obligation. And lastly, liability for fraud cannot be mitigated or reduced by the courts, while liability for negligence may be reduced according to the circumstances. Article 1171. Responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. Responsibility arising from fraud is demandable. This provision refers to incidental fraud, which is employed in the fulfillment of an obligation. Responsibility arising from fraud can be demanded with respect to all kinds of obligations, and unlike in the case of responsibility arising from negligence, the court is not given the power to mitigate or reduce the damages to be awarded. This is so because fraud is deemed serious and evil, that its employment to avoid the fulfillment of one's obligation should be discouraged. Waiver of action for future fraud void. According to the time of commission, fraud may be past or future. A waiver of an action for future fraud is void, no effect as if there is no waiver. As being against the law and public policy, a contrary rule would encourage the perpetration of fraud because the obligator knows that even if he should commit fraud, he would not be liable for it, thus making the obligation illusory. Waiver of action for past fraud valid. A past fraud can be subject of a valid waiver because the waiver can be considered as an act of generosity and magnanimity on the part of the party who is the victim of the fraud. Here, what is renounced is the effect of the fraud, that is, the right to indemnity of the party entitled thereto. The waiver must be expressed in clear language which leaves no doubt as to the intention of the obligee to give up his right against obligor. Example: A promised to deliver 120 cavans of rice of a particular brand and quality to be at the rate of 10 cavans a month. A cannot make an agreement with B, whereby B will not be file an action in court against A, should A commit fraud in the performance of obligation. This waiver of an action for future fraud is void. Hence, B will still bring an action against A for damages arising from the fraud. But once fraud is committed, B, with full knowledge thereof, can waive his right to indemnity as an act of forgiveness on his part. Article 1172. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts according to the circumstances. This means a party to a contract is relieved from the effects of his fault or negligence by a third person. Responsibility arising from negligence demandable. In the performance of every kind of obligation, the debtor is also liable for damages resulting from his negligence. Number 1. Discretion of court to fix amount of damages. The courts are given wide discretion in fixing the measure of damages. The reason is because negligence is a question which must necessarily depend upon the circumstances of each particular case. Moreover, negligence is not as serious as fraud because, in the case of the former, there is no deliberate intention to cause injury or damages. When justified by the circumstances, the court may increase or decrease the damages coverable. Number 2. Damages where both parties mutually negligent. When both parties to a contract are mutually negligent in the performance of their respective obligations, the fault of one may cancel or neutralize the negligence of the other. Thus, the rights and obligations of the parties may be determined under the equitable principle that no one shall enrich himself at the expense of another. Further details of Article 1172 will be discussed by Ms. Lantita.
Thank you, Ms. Morales. So now let's proceed to the next slide. Validity of waiver of action arising from negligence. So the first one, an action for future negligence, not fraud, may be renounced except where the nature of the obligation requires the exercise of extraordinary diligence, as in the case of common carriers. So this statement revolves around the legal principle that an individual can waive their right to pursue legal action for future instances of negligence, which is defined as a lack of proper care in carrying out a task, as long as it doesn't involve fraudulent activities. However, there's an exemption to this rule when the obligation involved necessitates a high level of care and attention, referred to as extraordinary diligence. In such situations where extraordinary diligence is required, the right to renounce action for future negligence cannot be waived, as stipulated in Article 1733. So let's proceed for the example. The law allows an agreement between S and B whereby S will not be liable for damages arising from negligence in the performance of his obligation. But if S is a common carrier, for example, is bus, shipping, or airline company, such waiver is void. So this example illustrates an legal scenario where an agreement can be made between two parties, S and B, stating that S will not be held accountable for any damage caused by negligence in the execution of their obligation. However, the law stipulates a special consideration when S is a common carrier, such as bus, shipping, or airline company. In such cases, the waiver that exempts S from liability for negligence is considered null and void, highlighting the higher standard of care required from common carriers. So next is where negligence is gross or shows bad faith, that is deliberately committed. It is considered equivalent to fraud. Article 2201, second paragraph. Any waiver of an action for future negligence of this kind is therefore void. So this statement explains a legal principle where if negligence is severe or demonstrate bad faith, such as being deliberately committed, it is equated to fraud as per Article 2201, second paragraph. So this means that such negligence is seen as intentional act to deceive or cause harm similar to fraudulent activities. Consequently, any agreement to waive the right to legal action for future negligence of this severe or intentional nature is deemed invalid or void. And now let's tackle the kinds of negligence according to source of obligation. So the first one is contractual negligence, culpa contractual, or negligence in contracts result in their breach. Article 1172 refers to culpa contractual. This kind of negligence is not the source of obligation. According to Article 1157, it merely makes the debtor liable for damages in view of his negligence in the fulfillment of a pre-existing obligation, according to Article 1170 and the Article 1172. So this statement discusses the concept of contractual negligence, also known as culpa contractual, which refers to negligence that occurs within the context of a contract, leading to its breach. According to 1172, specifically addresses this type of negligence. It's important to note that contractual negligence is not considered a separate obligation in itself, as stated in Article 1157. Rather, it holds the debtor responsible for damages due to their negligence in fulfilling an existing obligation, as outlined in Article 1170 and Article 1172. So the second one is civil negligence, culpa aquiliana, or negligence which by itself is the source of an obligation between the parties, not so related before by any pre-existing contract. It is also called tort or quasi-delict, according to Article 1162 and Article 2176. So this statement introduces the concept of civil negligence, also known as culpa aquiliana, which refers to negligence that becomes the basis of a legal obligation between parties who were not previously connected by any contractual agreement. It is alternatively referred to as tort or quasi-delict, as stated in Article 1162 and Article 2176. Unlike contractual negligence, civil negligence arises independently and establishes a legal duty between the parties involved. So next is criminal negligence, culpa criminal or negligence resulting in the commission of a crime. According to Article 365 of the Revised Penal Code, the same negligent act causing damages may produce civil liability arising from a crime under Article 100 of the Revised Penal Code supra, or create an action for quasi-delict under Article 2176 and the following of the Civil Code. So this statement discusses the concept of criminal negligence, also known as culpa criminal, which refers to negligence that leads to the commission of a crime, as defined in Article 3 and 365 of the Revised Penal Code. The same negligent act that causes harm can give rise to both civil liability under Article 100 of the Revised Penal Code and an action for quasi-delict under Article 2176 and subsequent articles on the Civil Code. In other words, the negligent act can result in both criminal and civil consequences depending on the circumstances and legal provisions involved. Article 1173. The fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of the time, and of the place. When negligence shows bad faith, the provision of Article 1171 and 2201, paragraph 2 shall apply. If the law and or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. Article 1173 of the Civil Code states that the fault or negligence of the person who has an obligation is determined by the level of diligence required by the nature of the obligation and specific circumstances involved. If negligence is accompanied by bad faith, the provisions of Article 1171 and 2201 paragraph 2 will apply. In cases where the law or contract does not specify the required diligence, the standard expected is that of a good father of a family. So now let's proceed to the meaning of fault or negligence. According to our Supreme Court, negligence is conduct that creates undue risk or harm to another. It is the failure to observe for the protection of the interests of another person that degree of care, precaution, and vigilance which the circumstances justly demand, whereby such other person suffers injury. So, fault or negligence, as defined by the Supreme Court, refers to conduct that poses an unreasonable risk or harm to another individual. It involves the failure to exercise the necessary level of care, precaution, and vigilance that the specific circumstances require in order to protect the interests of the other person. When this failure occurs, it can result in injury or harm to the affected individual. So now let's proceed to the factor to be considered. Negligence is a question of fact, its existence being dependent upon the particular circumstances of each case. It is never presumed but must be proven by the party who alleges it. In determining the issue of negligence, where loss or damage occurs, the following factors must be considered. So the first one is nature of the obligation. For example, is smoking while carrying materials known to be inflammable constitutes negligence. So the nature of the obligation is an important factor to consider when determining fault or negligence. For example, if someone is smoking while carrying materials that are known to be flammable, this would be considered negligent behavior. The act of smoking in such a situation creates an unnecessary risk and goes against the obligation to exercise caution and prevent potential harm. Therefore, the nature of the obligation plays the crucial role in assessing whether a negligence has occurred. So the next one is circumstances of the person. For example, a guard, a man in the prime of life, robust and healthy, sleeping while on duty is guilty of negligence. So, the circumstances of the person are important factor to consider when assessing fault or negligence. For instance, if a guard who is in the prime of life, robust and healthy, falls asleep while on duty, this would be considered negligent behavior. The duty of a guard requires vigilance, and attentiveness, and sleeping while on duty goes against these expectations. Therefore, the circumstances of the person, such as their physical condition and role, play a significant role in determining negligence. So the third one is circumstances of time. For example, driving a car without headlights at night is gross negligence, but it does not by itself constitute negligence when driving during the day. So the circumstances of time are important factor to consider when evaluating fault or negligence. For example, driving a car without headlights at night would be considered gross negligence as it poses a significant risk to oneself and others on the road. However, the same act of driving without headlights during the day may not necessarily constitute negligence, as visibility is generally better during daylight hours. Therefore, the specific time of the incident plays a crucial role in determining the level of negligence involved. So next is circumstances of the place. For example, driving at 60 kilometers per hour on the highway is permissible, but driving at the same rate of speed in Quezon Boulevard, Manila, when traffic is always heavy is gross recklessness. The circumstances of the place are an important factor to consider when assessing fault or negligence. For instance, driving at a speed of 60 kilometers per hour on a highway may be considered acceptable and within the limits of the law. However, driving at the same speed on Quezon Boulevard in Manila, where traffic is consistently heavy, would be considered gross recklessness. The specific location and its characteristics, such as traffic conditions, can significantly impact the level of negligence involved. Therefore, the circumstances of the place are crucial in determining the degree of fault or negligence. When the source of an obligation is derived from a contract, the mere breach or non-fulfillment of the prestation gives rise to the presumption of fault on the part of the obligor. Kinds of diligence required. What is diligence? Diligence is the attention and care required of a person in a given situation and is the opposite of negligence. Under Article 1173, the following kinds of diligence are required. So the first one is that agreed upon by the parties orally or in writing. So the next one is in the absence of stipulation that required by the law in the particular case, like the extraordinary diligence 18 required of the common carriers. So next is if both the contract and law are silent, then the diligence expected of a good father of the family, ordinary diligence. Under Article 1173, the first kind of diligence required is the one agreed upon by the parties, which can be expressed either verbally or in writing. This means that the level of diligence expected will be determined by the specific terms and agreements made between the parties involved. In the absence of any explicit stipulations, the second kind of diligence required is that which is mandated by law for the particular case. For example, common carriers are held to a higher standard of diligence known as extraordinary diligence. Lastly, if both the contract and the law are silent on the matter, the third kind of diligence expected is that of a good father of a family, which is an ordinary level of diligence that a reasonable person would exercise in similar circumstances. Whether or not the negligence of the obligor is excusable will depend on the degree of diligence required of him. Under number 3, for example, the obligor is not liable for damages where his negligence is one which ordinary diligence and prudence could not have guarded against. The determination of whether an obligor's negligence is excusable depends on the level of negligence required of him. For instance, under the third rule, an obligor is not held accountable for damages if his negligence is something that could not have been prevented even with ordinary diligence and prudence. This implies that if an unforeseen event occurs that a reasonable person could not have anticipated or guarded against, the obligor's negligence may be considered excusable. So further explanation and information will be given by Mr. Cacho about delay.
Thank you, Miss Lantita. And I hope you learned from her report, guys. So, before we proceed to the next topic, I would like to introduce my name first. I am Mark Vincent F. Cacho, and I will be the one who gonna discuss the next topic, which is about delay, kinds of delay, requisites of delay, and the effects of delay. Delay or mora. According to Article 1169, those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them to fulfill of their obligations. So, this means the Article 1169 is that demand from the creditor is generally necessary for debtor to be considered in delay, except in the specific cases. Okay? The exemption include when the obligation or the law expressly declares that demand is not necessary. Okay? When from the nature and circumstances of the obligation it's appear that the designation of the time when the thing should be delivered makes demand unnecessary. Or when demand would be useless because the obligor has rendered it beyond their power to perform. In reciprocal obligations, neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with what is required. And also, the article also outlines the effects of delay on both the debtor and the creditor, including liability for damages and the transfer of risks in certain situations. Next is meaning of delay. The word delay, as used in the law, is not to be understood according to its meaning in common parlance. A distinction, therefore, should be made between ordinary delay and legal delay, or default or mora, in the performance of an obligation. So when we say ordinary delay, is merely the failure to perform an obligation on time, whereas legal delay or default or mora is the failure to perform an obligation on time, which failure constitutes a breach of the obligation. These are two important concepts in civil law that we must know and understand whether we are lawyers or non-lawyers or non-law students just like us or law student. So in relation to these two concepts, we have a principle in law which states if there is no demand, then there is no delay. In that concept or in that statement, when we say delay, what types of delay are we referring to? Since we said there are two types of delay. First is ordinary delay, and second is legal delay. So what then is ordinary delay? Ordinary delay is non-performance of an obligation, okay, after the lapse of the agreed time. While in legal delay, there is also still the lapse of the agreed time and still there is no performance of the obligation. But, however, unlike your ordinary delay, in legal delay, there was already a demand that was made. Okay? Now, why it is important to determine whether this is merely ordinary delay or if this is legal delay? The reason for that is your civil law will tell you that if you incur delay, if there is delay, then you will be made liable for damages. So, what kind of delay will let you be liable for damages? The answer is legal delay. To further understood the difference between the two, let me give you an example. Maria and Marjorie agreed that Marjorie will deliver a particular car to Maria on July 20, 2021. Supposing today is already September 20, 2021, and still there was no delivery of the car yet by Marjorie to Maria. And it's already September 20, 2021. Clearly, there is a delay. But the question now is it the kind of delay that will entitle Maria to receive damages from Marjorie? Will it make Marjorie liable for damages? The answer is it's depend. It's depend on what? It's depend on whether a demand Maria has already made a demand upon Marjorie to deliver that particular car to her. If Maria has already made a demand upon Marjorie to deliver that particular car to her on or after July 20, 2021, which was two agreed period, and still Marjorie did not deliver the specific car, then Marjorie is liable for damages because there is already a demand that was paid by Maria upon Marjorie. In other words, if Maria did not make a demand upon Marjorie to deliver that particular car, even after the lapse of July 20, 2021, there was no demand made yet by Maria upon Marjorie. If today is September 20, 2021, and still there was no demand that was made by Maria upon Marjorie, then Marjorie still cannot be made liable for damages, okay? Because there is no legal delay yet. Again, if there is no demand, then there is no legal delay. If there is no legal delay, then you will not be made liable for damages. Next is kinds of delay or mora. For your information, there are 3 kinds of delay or mora. First is mora solventi. So what is mora solventi? Mora solventi, or the delay on the part of the debtor to fulfill his obligation or to give or to do by reason of a cause imputable to him. Meaning to say, mora solventi is the delay in the performance of an obligation on the part of a debtor. So there are 2 types of mora solventi. First is mora solventi ex re. So what is mora solventi ex re? Mora solventi ex re is a delay in real obligations or obligation to give. So meaning to say, the debtor is failing to perform the obligation of transferring ownership of an object or an item to the creditor. Let me give you an example. If a debtor has agreed to sell a house to a creditor on the condition of payment on a specific date, but he fails to transfer the ownership of the property even after receiving the payment, so it would be considered as mora solventi ex-re. The debtor is obliged to transfer the ownership of the house, but his delay in performing the obligation result in breaching the agreement between the parties. The second types of mora solventi is mora solventi ex persona. So what does it mean? Mora solventi ex persona is a delay in personal obligations or obligations to do. So meaning to say, the debtor is failing to fulfill an obligation to perform some task, such as providing a service or carrying out some specific action. Let me give you an example again. If a debtor has an obligation to paint a house by a specific date, but he fails to complete the painting by the specified date, it would be considered as mora solventi ex persona. The debtor's delay in performing the obligation to complete the painting in a breach of the agreement, which may result in legal consequences for the debtor. So, in short, mora solventi is a legal concept that defines the liability of a person who has failed to promptly fulfill their obligation towards another party and can help to identify the legal consequences of such a delay. Another kinds of delay or mora is mora accipiendi. So what is mora accipiendi? Mora accipiendi, or the delay on the part of the creditor without justifiable reason to accept the performance of the obligation. Meaning to say, the creditor is not willing to accept the debtor's fulfillment of the obligation in a timely manner. Let me give you an example. Imagine a scenario where a vendor is supposed to deliver goods to a buyer on a specific date as per their contract. However, when the vendor arrives to deliver the goods on time, the buyer refuses to accept the delivery without any valid reason. So in this case, the buyer's delays in accepting the goods could be considered as mora accipiendi. The third kinds of delay or mora is compensatio morae. So what is compensatio morae? Compensatio morae is a delay of the obligers in reciprocal obligations like in sale. So this is the delay of the obliger cancel the delay of the obligee and vice versa. So let me give you an example. Let's consider a case where Mr. Cacho agrees to deliver goods to Miss Jamil by a certain date, and in return, the buyer is supposed to make the payment on the same date. If Mr. Cacho experiences a delay in delivering the goods but eventually delivers them later, and Miss Jamil also experiences a delay in making the payment, these delays could offset each other under compensatio morae. This means that the delay of one party, both seller or buyer, which is Mr. Cacho and Miss Jamil, cancel out the delay of the other party due to the reciprocal nature of their obligation. So, meaning to say, compensatio morae addresses the principle of mutual delays canceling each other out in reciprocal obligations. So there is general rule. So when the debtor incurs in delay from the time the creditor demands fulfillment of the obligation either judicially or extrajudicially, but the debtor fails to comply with such demand. So meaning to say, no demand, no delay. So that is the general rule. No delay in negative personal obligation. In an obligation not to do, non-fulfillment may take place, but delay is impossible for the debtor fulfills by not doing what has been forbidden him. Meaning to say, negative personal obligation is an obligation not to do something. There is no possibility of delay. However, when it comes in positive personal obligation, the debtor incurs in delay when the creditor demands fulfillment of the obligation, either judicially or extrajudicially, and the debtor fails to comply with such demand. In other words, in positive personal obligation, there must demand from the creditor to trigger the debtor's delay. To break it down, negative personal obligation typically involves refraining from doing something. It could be an obligation not to disclose confidential information or not to compete against a business partner. So that is an example. So in this case, there can be no delay since it's simply a matter of a debtor refraining from taking action. So let me give you an example. A scientist signs a non-disclosure agreement with the company, agreeing not to disclose any confidential information. So in this particular example, there is no concept of delay because the scientist just needs to abide by the agreement and refrain from disclosing the confidential information to anyone. In terms in positive personal obligation involves performing a specific action or task. It could be an obligation to pay a debt or fulfill a contract. So that is an instance. In this case, the debtor incurs in delay when the creditor demands fulfillment of the obligation, either through legal means or judicial or outside the courts or extrajudicial, and the debtor fails to comply with the demand. Let me give you an example. A borrower has a loan agreement with the bank, wherein they are required to make monthly repayments. If the bank send a written notice demanding payment, and the borrower fails to make the payment within a reasonable time after receiving the demand, it will be considered a delay on the part of the debtor. The delays occurs because the creditor has demand fulfillment of the obligation, which is the payment, and the debtor has failed to comply with the demand. So, meaning to say, the absence of delay in negative personal obligation means that there is no concept of delay as there is no action required from the debtor. However, in positive personal obligation, a delay occurs when the creditor demands fulfillment of the obligation and the debtor fails to comply with the demand. Without such a demand, there can be no delay. The requisites of delay or default by the debtor are also known as mora solventi. That consists of three conditions that must be met for its effect to arise. The first condition is the failure to the debtor to perform his positive obligation on the agreed upon date. So, meaning to say, the debtor does not fulfill the action or task that they are required to do according to the terms of the agreement. Let's say, for example, if a contractor has a contractual obligation to deliver construction materials to a construction site by a specific date but fails to do so. So, it constitutes a failure of the debtor to perform the positive obligation. The second condition is the demand made by the creditor to the debtor to fulfill, perform, or comply with the obligation. This demand should not be a mere reminder or notice. It must be a formal request for the debtor to fulfill their obligation. The demand can be either judicial, when initiated through a court complaint, or extrajudicial, made outside of the court. So let me give you an example. A landlord sent a formal re-end notice to the tenant requesting the payment of overdue rent within a specified time frame. This re-end notice serves as a demand for the tenant to comply with the obligation of paying rent on time. Third condition is the failure of the debtor to comply with the demand made by the creditor. So, if the debtor does not fulfill their obligation, even after receiving a formal demand from the creditor, then they are considered to be in default or delay. For example, an individual borrows monies from a friend with a signed agreement to repay the loan within a set time frame. After the lender sends a re-end notice demanding repayment, the borrower fails to comply within the stipulated period. It is resulting in the debtor's default. So, these three conditions together contribute to the concept of moral solvency, indicating the debtor's delay or default in fulfilling their obligation under the agreement terms. So next is the effect of delay. Effect of delay in moral solvency. The first effect is the debtor is considered guilty of breach of the obligation. So meaning to say, the debtor has failed to fulfill their payment obligation within the agreed upon time frame. The second effect is, in case of obligation to pay money, the debtor becomes liable for interest or damages in other types of obligation. This means that the debtor may have to pay additional amount as interest for any losses suffered by the creditor due to the delay. The third effect is the debtor is liable even for a fortuitous event, an unforeseen event beyond their control, when the obligation is to deliver a specific thing. This means that even if the loss or damage to the thing being delivered is due to a fortuitous event, such as natural disaster, the debtor is still responsible for it. Okay? However, if the debtor can prove that the loss would have occurred regardless as their default, the court may reduce the damages in equitable manner. The next effects of delay is effect in mora accipienti. So the first effect is the creditor is considered guilty of breach of the obligation. This means that the creditor has failed to accept the performance or delivery of the obligation within the agreed upon time frame. The second effect is the creditor is liable for damages suffered by the debtor due to the delay. This means that if the debtor incurs any losses or additional expenses as a result of the creditor's delay in accepting the performance or delivery, the creditor may have to compensate the debtor. Okay? The third effect is creditor bears the risk of loss of the thing due. This means that if the thing being delivered or performed is lost or damaged during the creditor's delay, the creditor is responsible for the loss or damage. The fourth effect is, in the case of obligation to pay money, the debtor is not liable for interest during the creditor's delay. So, meaning to say that the creditor delays accepting a payment, the debtor is not obligated to pay additional interest on the outstanding amount during the period. The fifth effect is when the debtor may release themselves from the obligation by consigning depositing the thing or sum due. So, this means that if the creditor continuously refuses to accept the performance, the debtor can fulfill their obligation by depositing the thing or sum due with the proper authority or court. This deposit, known as consignation, releases the debtor from their obligation. The next effects of delay is effect in compensation morale. The effect in compensation morale is when the delay of the obliger cancel the delay of the obligee and vice versa. Legally speaking, there is no default or delay on the part of both parties. If the delay of one party is followed by that of the other, the liability of the first infractor shall be equitable, tempered, or balanced by the courts. If it cannot be determined which of the parties is guilty of delay, the contract shall be deemed extinguished and it shall bear his own damages. Let me give you an example. A contractor is delayed in completing a construction project due to unforeseen circumstances, such as a labor strike, and at the same time, the client is delayed in making payments for the completed work due to financial difficulties. So, if it is cannot be determined who caused the delay, or if both parties are at fault, the contract may be deemed extinguished and each party will bear their own damages without the liability to seek compensation from the other party. And that will be my part, and the further information will be discussed by the next reporter, which is Miss Althea May Graho.
Thank you, Mr. Cacho. But before I continue the discussion, let me introduce myself. I am Althea May Graho, and now I will discuss the when demand is not necessary to put debtor in delay. When demand is not necessary to put debtor in delay, as a general rule, delay by the debtor begins only from the moment of demand, judicial or extrajudicial, for the fulfillment of the former's obligation is made by the creditor. Without a such amount, the effect of default will not arise. The exemptions are mentioned below. Number 1. When the obligation so provides. Example: D promised to pay C the sum of 20,000 pesos on or before November 30 without the need of any demand. Therefore, if D fails to pay on November 30, he is automatically in default. In this case, the parties stipulate to dispense with the demand. The mere fixing of the period is not enough. The arrival of the period merely makes the obligation demandable. Before its arrival, the creditor cannot demand performance. The obligation must expressly so declare that demand is not necessary or must use words to the effect. As for instance, the debtor will be in default or I will be liable for damages. Number 2. When the law so provides. Example: under the law, taxes should be paid on or before a specific date. Otherwise, penalties and surcharges are imposed without the need of demand for payment by the government. Number 3. When time is of the essence. Example: the delivery of balloons on a particular date when a children's party will be held. The making of a wedding dress where the wedding is scheduled at a certain time. Payment of money at a particular time so that the creditor could pay off certain debts due on the same date. The delivery of a car to be used in a trip at particular time, etc. In all of the foregoing cases, the debtor will fully aware that the performance of the obligation after the designated time would no longer benefit the creditor. In arrangement of this kind, time element is important as performance itself. When the time of performance is not fixed or is stated in general or indefinite terms, time is, as a rule, not of the essence of the contract, in which case performance must be made within a reasonable time. What is a reasonable time will depend on the circumstances of the particular case. Number 4. When demand will be useless. Example: S obliged himself to deliver a specific course to B on September 5. Through S negligence or deliberate act, or by reason of fortuitous event, for which S has expressly bound himself responsible, the horse died on September 2. Under this situation, any demand for the delivery of the horse on September 5 would be useless as S has made it impossible for him to perform his obligation. Number 5. When there is performance by a party in reciprocal obligation. In case of reciprocal obligation, the performance of one is conditioned upon the simultaneous fulfillment on the part of the other. So neither party incurs in delay if the other does not comply or is not ready to comply in a proper manner with that is incumbent upon him. This is compensation mores. From the moment a party fulfills or is ready to fulfill his obligation, delay by the other begins the event must be unforeseeable, or even if it could be foreseen, must be impossible to avoid. That's all for the delay, and now we will move on to the fortuitous event. A fortuitous event is any event which cannot be foreseen or which, though foreseen, is inevitable. Stated otherwise, it is an event which is either impossible to foresee or impossible to avoid. The essence of a fortuitous event consists of being a happening independent of the will of the debtor, and which makes the normal fulfillment of the obligation impossible. In simple words, fortuitous event is unpredictable events connected with the acts of natural forces occurring independently of the person will. A fortuitous event may either be an act of man or act of God. The first one is act of man. Strictly speaking, fortuitous event is an event independent of the will of the obligor but not of the other human will. Example is such as riots, murder, war, robbery, and fire. The second one is act of God. They refer to what is called major, or those events which are totally independent of the will of every human being. Example is natural occurrences such as earthquake, eruption of volcano, and also the virus. In our law, fortuitous event and force majeure are identical insofar as they exempt an obligor from liability. Both are independent of the will of the obligor. There are two kinds of fortuitous event. In speaking of the contract of lease, our civil code distinguish between two kinds of fortuitous event. Number one is ordinary fortuitous event. This is events which are common and which are the contracting parties could reasonably foresee. Example is the rain. The second one is extraordinary fortuitous event, or those events which are uncommon and which the contracting parties could not have reasonably foreseen. Example are earthquake, fire, war, and unusual flood. Article 1174 of the Civil Code states that no person shall be responsible for a fortuitous event that could not be foreseen or, though foreseen, was inevitable. In other words, there must be an inclusion of the effect human intervention from the cause of injury or loss. The burden of providing that the loss was due to a fortuitous event human rests on him who invokes it. And in order for a fortuitous event to exempt one from liability, it is necessary that one has committed no negligence or misconduct that may have occasioned the loss. Requisites of a fortuitous event. Number 1. The event must be independent of the human will, or at least of the debtor's will. This means that the event causing the inability to fulfill the obligation should not be within the control of the party involved. It should be an external factor that the party could not have prevented or influenced. Number 2. The event could not be foreseen, or if foreseen, is inevitable. This states that the event causing the inability to comply with the obligation should be either be unforeseeable or, if foreseeable, unavoidable. Number 3. The event must be of such a character as to render it impossible for the debtor to comply with their obligation in a normal manner. This requires that the event makes it genuinely impossible for the party to fulfill their obligation in the usual or normal manner. Number 4. The debtor must be free from any participation in or the aggravation of the injury to the creditor, meaning there is no concurrent negligence on their part. This states that the party seeking force majeure relief should not have contributed to or worsened the situation that prevented them from fulfilling their obligation. These requisites help determine whether force majeure applies in a given situation, allowing the affected party to be excused from their contractual obligation. It's important to note that the specific application and interpretation of force majeure may vary depending on the jurisdiction, and the term of contracts. Rules as to the liability in case of fortuitous event. Number 1. When expressly specified by the law. In exception A, B, and C below, the special strictness of the law is justified. A. The debtor is guilty of fraud, negligence, or delay or contravention of the tenor of the obligation. Example of this is S is obliged to deliver a specific horse to B on August 10. S did not deliver the horse on said date. If on August 11, the horse died because it was hit by lightning, S is not liable if no demand was made by B. His obligation is extinguished. If the horse died after a demand was made by B, S is liable for damages because he is guilty of legal delay. In this case, the obligation of S to deliver the horse is also extinguished, but it is converted into monetary obligation to pay damages. If the horse would have died in any event, even if no demand had been made by B, S would still be liable. A debtor in default becomes liable even for loss due to a fortuitous event. However, the court may reduce the amount of damages. The next is the debtor has promised to deliver the same specific thing to two or more persons who do not have the same interest. Example, if S sold and promised to deliver the same car to B and C separately, S is liable even for a fortuitous event. The reason is because it would be impossible for S to comply with his obligation to both B and C even without any fortuitous event taking place. The next one is the obligation to deliver a specific thing arises from a crime. Example, S stole the carabao of B. S has the obligation arising from the crime to return the carabao. Even if the carabao dies or is lost through a fortuitous event, S is still liable for damages unless B is in a mora acipendi. A person is responsible for the result of whatever cause which flow from his criminal act. The next one is the thing is to be delivered is generic. Example, the loss or destruction of a generic thing like rice, corn, sugar, etc. does not produce the extinction of the obligation because the debtor can still comply with his obligation by delivering another thing of the same kind in accordance with the principle that genus never perishes. The second rule is when declared by stipulation. The basis for this exemption rests upon the freedom of contract. Such a stipulation is usually intended to better protect the interests of the creditor and procure greater diligence on the part of the debtor in the fulfillment of his obligation. But the intention to make the debtor liable even in case of a fortuitous event should be clearly expressed. And the last rule is when the nature of the obligation requires the assumption of risk. Here, risk of loss or damages is an essential element in the obligation. Example, B insured his house against fire for 100,000 with C, an insurance company. Later, the house was destroyed by accidental fire. Although the cause of the loss is a fortuitous event, B may recover the amount of the policy. In a contract of insurance, the insurer, which is C, in consideration of the premium paid by the insured, which is B, undertakes to identify the latter for the loss of the thing insured by reason of the peril insured against, even if the cause of the loss is a fortuitous event. That's all for our report. Thank you for listening.